Oh, that was kind of loud. Hi, everybody. May 1st. Thanks for joining. We're going to talk about some interesting things. I always say that. It's interesting to me. I hope it is to you. I hope it helps you. Yes, you can record this. Hey there, Moko. So
Hi.
some clients are nice enough to share our work and let me discuss it. So we're going to do that this evening. Um, I will do it I will do it anonymously if you ask me to, but sometimes people don't, so it's okay. But I just want to mention the work that I do is published on video series, like curriculums, courses. You can take them, you can watch the videos, and then hopefully you'll learn how I do things, the strategies, the underlying thoughts behind what I do. And then also with the video series, there are documents that go along with it, so you don't have to create your own document. Sometimes there's not, but you can ask and we provide that. I provide that. We'll send it out to you. So, but aceofcoins.club is the website for the video series. And then if you want to do a consultation with me, so I set up a consultation and I just do that with a calendar. So you just pay for that time. I do a series though. I don't just do one call with you. It's going to be a series. And typically what I find is that people want or need maybe a document preparation, or what will happen is someone will set a time with me and it sounds interesting, and he'll want or she'll want to bring in a family member and have another call. So that's part of the deal. I do like 2 or 3 calls like that for the same price. I don't charge you more money for like 3 calls. Okay. And if I have to create some documents or something to help you, then fine. Then I have a consulting package. Okay. So with that, I usually set up an LLC or something. I'm not selling LLCs. You can do that yourself. You can pay somebody $100 to do one for you. What I'm doing is creating the consulting that shows you how to use what I'm giving you, what I'm writing for you, and I'm showing you why. And tonight we're going to get into that a bit. I want to show you how we're going to use an LLC as a tool. But before I do that, I want to get into the legal aspects of a pleading from a creditor lawsuit. So that's at aceofcoins.com where you can schedule a time with me and love to talk to you. So anyways, let's look at this. So I'm going to do a screen share. So this is typically what happens. So many people are afraid of uh, being sued. Of course, it's a problem, right? You got to deal with it because someone's trying to get your money. That's what it comes down to. They're trying to get your stuff, or they're trying to. What's going to happen is your credit's going to be affected. Your name's going to be in the public records. Nobody wants this stuff. And there's always the fear of going to jail, which is not going to happen in the civil proceeding, unless you do something stupid. It's just about taking your money, okay, for a claim. So, and before I get into this aspect of the summons or getting that notice in the mail, let me just mention another client was nice enough to share with me the results she had. So she got a letter from the IRS. This is the terrifying, this is probably the more terrifying one. I mean, maybe a summons with a process server, right? The sheriff comes to your door. That's probably terrifying too. But a letter from the IRS is kind of terrifying. So she got this letter, and basically the IRS said, this is like maybe last year. The IRS said, you underreported, and you should file or fix your tax return, and or you're maybe subject to penalties and this sort of thing. So that is kind of terrifying for people. And so she asked me, hey there, Ray. She asked me, hey, check it out. Look what I got. And it's a standard form letter. It's a notice of underreporting. Notice of underreporting. It's like during the examination phase. So I understand when you get a letter from the IRS, I know what point it is in the process. Okay, there's 3 segments. I'm not going to get into that tonight, but so I saw what was going on. So I said to her, now think about this. If you go to a lawyer with a letter from the IRS, the lawyer is going to get you into a payment plan. He's going to scare the pants off of you, and he's going to get you in a payment plan because that's what they do, because they're incompetent for the most part. Okay, he probably thinks that your lawyer probably thinks, when I say he, I mean he or she, thinks that getting a discount on the amount is a good idea. My thinking is never pay a dime. And I can tell you in 32 years, my clients have never paid it one single dime, needed to pay one single dime to any creditor, including the government, voluntarily. So never needed to do that because there's other ways to deal with it. And that's following the law. That's not a cheat or anything. So anyways, here's what I told her. Now, keep in mind, a lawyer is going to say, okay, well, I'll need a retainer and we're going to do an offer and compromise and all this nonsense. Or we'll file an amended tax return and get on our knees and beg for mercy. Okay. So I said, look, take the letter you got in the mail And on a 45-degree angle, I said, write the following phrase. I sent this to her by email or whatever. I told her, write, my tax return is not underreported. The changes you're proposing are inaccurate, and there are no changes necessary to my tax return. Now, the IRS wrote a letter back last month, I think it was a couple months ago. Does anybody want to guess what the IRS said? Now, this is a handwritten note on the IRS notice itself. What do you think the IRS said when I sent that handwritten note?
You will receive no further communications and need to take no further action. Something
Yeah,
like that.
basically, it said, you're right. You're right. You didn't underreport. We're going to close this file.
Not bad.
Excellent.
So what I'm saying is, you can be afraid of stuff. People tell me, people ask me all the time, should I be worried? And I say, well, you can be worried if you want to. I don't see what good that's going to do you. You can only do the right thing. You can only do something, legally. And so, yeah. So anyways, that's just one example. So now I'm going to show you something else. It's a bit more elaborate. Now, as much as I can show you this, and you can use what I'm going to tell you, you can win every credit card lawsuit, but it's a lot of work, but you can do it. My recommendation is if I show you how to do it, don't do it. There's a much easier way to defeat them. And it's very consistent with having a good estate plan and learning about the best use of capital. That's really what I want people to learn. I'm not just trying to beat Citibank. That's easy. Not pay them, that's easy. But if I understand my plan, okay, and I adopt a new plan for the use of my money, I'm going to come out way ahead down the road. Whereas if I'm just scared and I pay because I'm afraid of something I can't even describe on a piece of paper, well, I'm just going to be out the money. And then what? I didn't learn anything and I'm behind now. Think about it like this. Every debt you pay that's an old debt, that's not like I'm staying in my house because I'm paying my mortgage, that's a debt you should pay. But a credit card debt that the card's maxed out and they closed it on you, it's defaulted, never pay it because that sets you back. Okay, so let me just think for a second. I'm just going to make up a number. Every $1,000 you pay on a situation like that, like an old credit card debt, because you're afraid or you think it's going to fix your credit, which it's not, by the way, every $1,000 is probably setting you back 3 or 4 times the $1,000 because of the time value of money, and you're not learning something. So let's look at this pleading here. Let me do a share screen. So a client was very nice to let me show this. So he got this yesterday, I think. So I can tell you right now that I have dealt with, I'm not exaggerating. Let me think here for a second. Over 30,000 of these, well over 30,000 of these. Zwicker and Associates, old law firm, seen them come and go for years and years and years, ever since the 90s. Okay, now what's interesting is, okay, so you guys probably recognize this, right? A summons. Okay, once the summons is served upon the defendant, the court then has jurisdiction to proceed, and it must then evaluate the pleading as to whether or not, or what the scope of its jurisdiction at that point. But once you're served, you're in the party started, so to speak, okay? You can still argue jurisdiction even after judgment, okay? But what's interesting is if I just look at this thing, let's say I got it. Let's say I'm Luke and I get this thing and, I'm just like, I look at it like this. I'm not going to be afraid of it. Yeah, someone wants to get my property, but I look at it like I'm watching ants, okay? I don't get afraid of this stuff. It's just like if I'm playing a chess game, I don't know if the other guy's going to beat me. I never played him before. All I can do is do my best game, right? So I look at this without the emotional aspect. And I know that's probably impossible, but I'm trying to share this perspective with you because we deal with these things all the time as adults. We have money and people want it. Sometimes they have a right to get it. Sometimes we have a right to not let them. So as long as it's legal, I'm going to not let them just because it serves you and I don't care about them. So look down here. So there's a summons and then the attorneys sign on, right? You need one lawyer to represent the corporation, Discover Bank. What do we got here? Ashley, Anthony, Jacob, Eric, Asuni, Abby, Somei, and then the whole law firm. Do we need this many lawyers? Does it take this many lawyers to sue this guy? Who is he? Who's this guy? Was he the Supreme Court justice or something? I mean, do you really need all these lawyers? I mean, right there should tell you something. So this is how I look at these things. Okay, so the first thing I like to do is just like, I'm just looking at, okay, so I really feel sorry kind of for the lawyer. That's his job. This is his trade. This is what he has to do. Somebody has to do it. Just like somebody has to wash the dishes at the restaurant. Well, these guys, they have to do this. So, and there's some formalities here. We don't care. It's interesting that it's in Florida, so that gives us some information. But anyways, here's the complaint. So the plaintiff is Discover and he's suing Luke, and it just makes a general allegation. This is probably necessary. I don't know, who cares? And so this is a jurisdictional statement. Okay, so what they're saying is, excuse me. Okay, this right here, this statement that says this is an action, a complaint for damages that does not exceed $50,000. So if it's under $50,000, it can be filed in the county court, where in Florida, that's the small claims court. Okay, you guys probably understand this. If it's the circuit court, it's going to be more than $50,000. Okay, that's what that's all about. Now, I've seen cases before where this is when the numbers were different. Like I think it was somebody was suing in Florida for $20,000. No, he was suing for 20 in small claims court, which the limit was $8,000. And I moved to dismiss the case because he was in the wrong court, and the judge says, no, I can hear it. And also they can waive the difference. So, you know, I was learning way back in the 90s on this stuff. So it's quite interesting how that plays out. So this is important. So this is the type of cause of action. He's being sued for this, what's known as a cause of action, a reason. So there could be a reason, for example, one reason to sue somebody on a debt would be if I sent somebody a bill and he didn't pay and he didn't object, I can sue him for a stated account. If I sue for a breach of contract, I have a higher burden of proof than for a stated account or what's known as an open account. Those stated account and open account causes of action are different. I have to say different things to the court. So when I see breach of contract as the cause of action, I'm kind of happy to see it. It's kind of like, if it's like if you're accused of a severe crime, okay, that's the burden of proof is very high, but you didn't commit that crime. You committed a lower, like a misdemeanor crime, right? Well, that would help you because the burden of proof is so high, your chances of being convicted are almost none. So when I see breach of contract, I'm thinking, okay, cool. So here's what I'm going to start focusing on. The type of pleading is a complaint for breach of contract. There must be a contract. So maybe Ray or Moko, what do you think? What's in a contract? What are what kind of things make a contract?
The terms, the parties
Should it be in writing?
should be in writing.
With a bank and a credit card, yeah, it should be in writing because you're
Yeah, in this situation.
Yeah. And so as far as the written version of the contract, can I have a contract that's perpetual from the beginning of time till forever?
No, I don't think so.
That probably wouldn't be a contract, right?
No.
What if I have terms of a contract where the date of commencement of the contract is not stated?
That would be a fault of the contract. It would have to state when it starts and when it ends. Wouldn't it?
So, right, it would have to identify periods of time or something like that, or how it's perpetual or when it goes into default.
Yeah, like one of those terms.
Yeah. And what if I had terms of a contract where there's no indication that the other party agreed to it?
It's not a
Unconscionable.
contract.
Unconscionable contract.
It's not a
Well,
contract.
it's not a sumsit. It's not a sumsit. There's no
Oh, a little Latin word
yeah,
there.
there was no meeting of the minds or no
Right.
evidence of the meeting of the minds, right?
Right.
So let's just give him the benefit of the doubt and say, well, okay, how about, did you ever serve him notice of the terms of the contract because you gave him a credit card? And if you did, where is it alleged in the complaint? And where's your evidence of it? Like, where's the notice? Okay, so with that in mind, let's say the action is based on a credit card account agreement, contract agreement. Let's just say they're all the same. All right. Let's see, defendants used or authorized the use of an account to incur charges. So this is a standard allegation that must be in this type of cause of action. The defendant used or caused to be used a credit account, incurred charges, and then Exhibit A is the contract. Very important.
Yeah.
Now, plaintiff relies on the choice of law provision, meaning that we're supposed to assume in Florida. In this case, in the contract, it says if we choose, we could have gone to arbitration, which they didn't choose. The lawyers chose to go to court. Fine. It's much better in my opinion. And then we have a record of the account statement. So what this is one monthly bill.
Okay.
All right, I'm gonna show you how to look at this stuff. So the defendant defaulted. They must say that. All right. So the facts regarding default would be what? There's got to be a payment term. It must be periodic.
Mm-hmm.
And then there must be a specific date or time period in which when payment is not received is considered default. And then there's provisions to cure default and or whatever. Right? It's got to have all these things in there, right? Okay, so we're not even going to get that far, you'll see. So terms and conditions, accelerated the full balance. That's how you cure default, by the way. You pay the full balance. So the lawyers want or just wants $11,000. All right. Now, plaintiff has to allege that it satisfied all notice requirements. That's what's going on here. So if you can maybe understand, maybe follow along with what I just explained, isn't it a bit less stressful? Hopefully you guys never get sued. But if you were to receive something like this, or your friend was able, was maybe in that situation, would you be able to look at it like I just described? Like I'm looking at an ant pile with a magnifying glass.
Right. It's useful.
I don't have any emotional connection to the ants.
Yeah.
I don't care. So, and I know people want my money, but I'm not afraid of that. They can try to get it. All right. So it's very interesting how they have their professional corporation here, and then poor old Abby, she's the one. Now this is important. So Abby, she's the attorney of record. This is important.
Which is funny because it says Ashley Blanco up top.
Well, but I know, yeah.
Yeah.
So it doesn't matter what's up top. What matters when you look at a pleading,
Mm-hmm.
that signature line right there,
Uh-huh.
end of the pleading under the wherefore,
Mm-hmm.
that attorney is liable for everything going forward.
Okay.
Now, these other lawyers, they're not of record.
Mm-hmm.
The only way they can become a part of the record, part of the proceeding, is by filing a notice of appearance. It's not enough to list the names in the summons. That doesn't make them part of the proceeding.
Okay.
Whoever signs the pleading is the attorney of record.
Okay.
If any lawyer comes in there and starts filing stuff and signing documents,
Mm-hmm.
move to strike for the attorneys intruding upon the case and not filing a proper notice of appearance and basically being rude. How dare you, come into the proceeding and say, Judge, this is your house. You're going to let this happen? So it's important to make note of this. So let's look at Exhibit A. Here we have the card member agreement. How do I know it's the card member agreement? How would I know that? Well, there's a big phrase at the top here. It says card member agreement. Right? Right? It just says it there. Right? What if there's a cartoon strip underneath? Could I still have it be the card member agreement? What if someone drew a Walmart smiley face under there?
No.
Okay, so the appearance of it at face value is that it says card member agreement, but if the substance is not an agreement, it ain't no agreement.
Right.
All right, so
Let's see.
Did you challenge right of agency of the attorney?
We don't need it. No, I never do that. No, not in that case. There's sometimes I can do that, but this is not. No, this is like saying you didn't shine your shoes this morning. It's not a thing. Sometimes standing in agency is important, but in this case, we can beat the crap out of them this way. I'm going to show you how to attack this from just looking at the pleading and the exhibits. Now, Exhibit A is an allegation.
Mm-hmm.
All right. Exhibit B is another allegation.
Right.
All right. So sometimes I've had cases where the allegations in the pleading literally conflict with what they exhibited. And the attorneys probably aren't even reading this stuff. So
Oh,
a lot of times I've had judges, make comments and say, well, that's a good argument. What do you say to that, counselor? And they're like, because they didn't read it. So just like any agreement, if you all have ever signed agreements, what does it say at the very beginning? Doesn't it identify the names of the parties?
can you make it a little bigger for,
Yeah,
thank you.
how about like that? Okay. All right. So we
Thank you for
we do
choosing.
we do we
Thank
do have
you.
we do have the name of one party, Discover Card,
Mm-hmm,
and blah blah blah, but I don't see a date anywhere so far. So
right.
acceptance,
If you do not cancel your account
you
within 30
accept this
days.
agreement. You, who's you?
Yeah,
Doesn't say.
exactly. You.
Is the judge? Is it whoever reads? Right, because maybe the judge is now liable. It doesn't say.
Right.
Whoever reads this is right. Okay, so you got to take this stuff literally. All right, so
Yes, yes.
this is typical language. Okay, this is an example. So far, it's an example of what you would think is in a credit card agreement. Okay, you got to get.
Mhm.
All right, now if you go on the internet and you search for Discover Card Member Agreement, you'll find this.
Mhm.
Just Google it. You'll find it. And then you can come in and show the judge, say, Judge, I just Googled this and I found this exact thing on the internet. So does that mean everybody who reads this is now liable to Discover? Because that's what they're doing here.
Mhm.
You see.
Interesting.
So let's look through this. It's talking about typical things like using your account, permitted uses, all this stuff, joint account checks, all this stuff. Fees, late fees, typical things, right? Here's your percentage rates. Here's how you make payments. If you have a dispute, how we apply them. Now, one of the things I look for in these contracts is you're in the default terms,
Mhm.
okay? But it's saying you, but it's not
Mhm.
identifying who you is. Collection costs, merchant disputes. Merchant disputes come in, invoke the Fair Credit Billing Act, by the way. I don't use the Fair Credit Billing Act because that assumes that you had an agreement with them. I like to argue that I never had an agreement. I don't know these guys. I don't have an
Right.
agreement with them. I hate those. I hate Discover Bank. I would never have a contract with them, right? Because why wouldn't I say that? Because they don't have evidence that I even know them. I never heard
Right.
of Discover before, even though last year I stopped making payments. So they have a privacy policy, which basically says how much privacy you don't have. And then they're a credit reporting agency. They have to tell you all this stuff. And then they shift the burden on you, right? If you lose your card and someone's using it and you don't tell them, then you're liable. They shift something and then the cancellation, you can cancel your account, all this stuff, right? So standard things. All right, now let's go into here. You see here, there's an arbitration clause, right?
Mhm.
Now, I always like to look at the language. And if you look at this language here at the very bottom of this paragraph, it says, either you or we may choose to resolve the claim by binding arbitration as described. Any claim challenging the validity or enforceability of this arbitration agreement, including class action waiver, may be resolved by, it says, may be resolved by binding arbitration. If either party requests it. This means if either you or we choose arbitration, neither party will have the right to litigate. So if a party files a case in court, he has every right to do that. You can't really require him to go into arbitration, which I don't recommend. I recommend against arbitration in these matters. It works in your favor. You want discovery. You want the rules of pleading practice and all these formal rules because it's going to help you. So sometimes the arbitration clause says there is no choice. You have no choice. Either we or you must go to binding arbitration. We have waived our rights to go to court. But it doesn't say that here. It says we have a choice. So just be careful on that. Now, the reason why I bring this up to you is because I've had cases like there was a case in Florida. It was a foreclosure and it was a second lien foreclosure. And the attorneys brought the case in court and I filed a motion to dismiss. In fact, the month before I filed the motion, there was another case in Florida that went to the appellate court and the appellate court ruled that when there's a binding arbitration clause that requires arbitration, if the party sues instead, he waives his right to arbitrate and the case is dismissed because the court doesn't have jurisdiction when there's a binding arbitration clause. And I won that just because the attorney didn't read it. And I cited the case that just happened like a month before. It was really convenient. So it's very important. Now, in this case, it doesn't even matter. They filed the case in court, not an issue anymore. Okay. All right. So we get into we don't need to talk about it. We don't care about that. I don't care about that. It's not going to help you unless you want to acknowledge that it's your credit account and then someone stole your account and made unauthorized charges and you disputed it and the bank didn't do anything about it. Okay, now you have a claim under the Fair Credit Billing Act, or they overbilled you or they double billed you, things of this nature under the Fair Credit Billing Act. I don't care about those things, but in very rare situations, it may apply. It's under Title 15, just so you know, under Title 15 section of the USC, section 1601, probably section 1681 and 1692, but 1601, you'll find this Fair Credit Billing Act, okay, for billing rights. But again, it's not what I'm talking about here. I just want to throw that at you. Now, Exhibit B, bill you get in the mail, right? So all this shows is a bill. It looks like a bill, but there's no evidence that the defendant received it. There's no evidence that the defendant received notification of this bill. What we do have evidence of is that the plaintiff probably has a computer and probably has a printer. That's it. This bill does not establish a debt.
Like the IRS.
Well, kind of. I mean, but you have to acknowledge that the allegations in the pleading and the exhibits, Exhibit A and B,
Mhm,
give the presumption of a debt obligation,
mhm.
but it's rebuttable.
Right.
So I'm going to show you how to rebut it momentarily. But as you can see, they've got his name and address, right?
Mhm.
Well, that just means somebody with some software went on Intellius and got his name. I could do that too. I could put the judge's name here. It doesn't mean anything just because they have his name and address. There's no exhibit here demonstrating that the defendant either received notice of the terms, received a bill on some particular date. There's no postmark here. There's no allegation that he received this bill. Is there? I mean, what's the date of the bill? Look on that.
January 12th.
Okay. Is there an allegation that he received the bill on January 12th or thereabouts in January?
No.
A record of the account. That's an insufficient allegation.
Got it. Mhm.
It doesn't allege that he was noticed on a particular date or anything of this nature. Now, go back to Exhibit A. We see no date. So if you can't have a contract with no commencement date. That's like saying, yeah, I'm married. I've been married for all of time. It doesn't make any sense, right? So
Mhm,
how can I have a financial obligation for all of time?
mhm.
Doesn't exist. So it's void for the fact that this, first of all, doesn't demonstrate the defendant's, first of all, knowledge that this even existed. And it fails to demonstrate the defendant's ability or having considered the terms, first of all. It fails to demonstrate that he considered these terms. How would we do that? I don't know how you would do that with, maybe you'd have to have a witness, right? I don't know.
Well,
And
it's not signed or dated.
then we get into the other part, which
Yeah.
is to demonstrate his consent to the term.
Right, right.
Now, I'm not saying it needs to be signed, although that would be a good way to do it. You could have a DocuSign signature and then authenticate it with his IP address. That's done. Those are more difficult actually to argue against, because you're going to have to argue that somebody came into your house and agreed to that with your user ID, so that's
Mhm.
hard to do, right? But when it's like this, there is no evidence appearing anywhere on this document, Exhibit A, demonstrating, first of all, that the defendant was noticed as to these terms, that he had any cognizance of the terms, or that he consented to any of the terms. And there's a lack of consideration alleged in the complaint. There's more elements for breach of contract. Okay, the contract, they didn't the lawyers didn't allege anything about the contract, that it was served upon him on this particular date, the contract commenced on a particular date. See Exhibit A, look at the date of the contract. Not there, and it's not alleged.
Mhm.
So there's no demonstration by Exhibit A that he consented to any of these terms. And so my argument is that I never heard of you guys before. I don't know who you are. Never heard of you. Because what are they going to do?
Well,
You have,
amend the complaint, or they, even then?
yes, thank you, Moko. So the best that can happen, and I've had this happen before, where we beat him squarely and the judge granted our motion to dismiss, which is unusual. And then he gave him like so much time to amend the complaint, and all they did was add the dollar amount. They made it higher. Everything else was the same. They didn't cure anything. So they filed a second amended complaint, and then the judge granted our motion again. And he gave him yet another 7 days to amend the pleading. And then I told my client, I said, do you want to keep doing this, or do you just want to just go on with the rest of the thing, which I'm going to explain to you right now? He goes, yeah, it's interesting, but I don't want to keep doing this, because what will happen is, even though we can keep on beating him, eventually the judge will give him the case, even though he shouldn't, because your remedy is to appeal it, and he's going to make you appeal it and not them, because you're not with an attorney. If you're with an attorney, no attorney's going to tell you what I'm telling you. You have to do this by yourself. Okay. Just because the lawyers or you're not going to prevail, which is true in the trial court. But if you want to win, what you do is you make correct arguments as to the insufficient pleading and lack of evidence, and you cross-examine their witness. So we can get into complicated things, but you make your case, okay? But what will happen is the judge will rule against you just because you're not a lawyer, and he'll force you to appeal it, which is just part of the proceeding. Okay, so you're basically, you have your ticket to the appeals court. So you file your notice of appeal, and then you make your legal argument, you file a brief, and you'll more than likely win. And I could tell you, in 32 years of doing this work, I think I've done it once. And I don't care, because I'm wasting my client's time. I'm wasting my time. And how am I going to justify my time? My time's expensive. And how am I going to justify? I have to do something to solve my client's problem. I'm not just trying to sell you my time. That's not going to solve your problem, right? So, like, for example, this case right here, I would charge like probably $10,000 to defend it. It doesn't make any sense. So I'd rather do like this video and show you the effective thing to do here. So I don't want to go, we can pick it apart all day long. There's some better ones too. I mean, this is a really nice basic example, okay? So let me just stop share. All right. So you see what happens, how you look at this stuff. What they're trying to do is make certain allegations to get the court to accept the jurisdiction. If you file an answer, then you're not challenging jurisdiction. You can file an answer, and you can add it as an affirmative defense that the complaint fails to state a cause of action because the pleading is insufficient, and you can make that argument in your answer, but you've answered the complaint, which is fine. I don't like that strategy. I like to ask for a dismissal first, and I argue there. And if my motion to dismiss is denied, then I have so many days, probably 10 or 20 days, to file a written answer. And then I take the arguments I made in my motion to dismiss and I turn it into an affirmative defense. So it never goes away. And the reason why I do that is because later on I can file what's called a dispository motion, dispose of the case, like a motion, like maybe a motion for judgment on the pleadings, motion for summary judgment. Okay, that's a good one. Based on my original argument that the judge didn't want to let me win on. Okay. And I have a really good chance of doing that. Alex, what do you think?
Hey, John. So, as you know, we have been doing this for the past several months, this exact type of case. Right. And it has turned into an affirmative action on my end because the original creditor dropped the case with their law firm.
The what?
With their law firm. So, yeah. But basically, I never had the chance to even fight the original suit against me because they dropped it, right?
You know, this brings in something that I didn't mention yet, but thank you for bringing that up. So keep in mind, a law firm is not allowed to practice law.
Good point. Important point.
So just realize when you're looking at a pleading like this and you see Zwicker and Associates, PC, ignore that. All you care about is the attorney whose name appears on the signature. Sometimes two of them sign their name. They're so stupid. So whoever signs his head's on the chopping block. You could beat the crap out of him, okay? Because he doesn't do it. He doesn't know what he's doing, typically. But it's the individual attorney who's liable. Now, what Alex did, he got sued by some creditor like this one, okay? And he just went and sued the law firm for unfair and deceptive collection practices in the US District Court. And when they got that, they withdrew the case, right? Is that what happened?
Well, actually, they withdrew the case before they even followed through on the original suit against me, and I'm currently in the process of the FDCPA case in
Yeah,
the
so
district court.
this is another way to really, I mean, you can get paid. You can actually make some money. It's not much, but I mean, you can make some money for it. So, I mean, that's another way to beat them in the trial court when they sue you for a credit card debt is you go around and sue them in the US District Court for unfair and deceptive collection practices. And I'm not going to get into how you do that. I'm just
Right.
saying, yeah. And so that's
So in Luke's case, though, right now, how would you the best action for him to take would probably be a motion to dismiss, and would you just go through the allegations and show how they're
Yeah.
insufficient?
So what I would do is this: I would write a motion to dismiss, and I would say the defendant moves the court to dismiss the complaint for its failure to state a cause of action or claim upon which relief can be granted. And I would further allege as follows. And the first thing I would say is that the complaint alleges a breach of contract, but fails to exhibit the contract.
Right. I mean, there's not even a signature. There's no name on the agreement.
Well, then I go
There's
and
nothing.
explain. I go and explain. Exhibit A is an example of a contract, but it's not a contract between the parties. It doesn't have a date. It's not a forever contract for all of eternity. You can't have a contract like that. It doesn't exist. So that's how you say it to the judge in the motion to dismiss. That the plaintiff acts, his allegations are as if there's a contractual agreement that exists for all of eternity, has always existed, and will always exist because it's not dated. Right? If you say it like that, ooh, that judge is going to say, man, I can't help you. I'm sorry. He's going to say to the plaintiff, I can't help you guys.
So what does the creditor do if you bring that motion and the judge says,
Well,
dismiss
the other
case?
aspect of it is that the exhibit A fails to evidence or demonstrate that the defendant ever had cognizance of the terms and fails to demonstrate his consent to the terms. It also fails to allege consideration, and it also fails to allege the date on which he would have consented. You see, it's so easy. You just 1, 2, 3, 4, right? Fails to state a cause of action or claim upon which relief can be granted. Here's why. And then wherefore, defendant respectfully requests this court grant the motion to dismiss with prejudice. Fair, I should say, to the plaintiff, because the judge should and would say to the attorney, hey, it makes sense. Why don't you, I'll give you guys a couple of weeks. How much time? They'd say, how much time you need, right? And they'll say, 2 weeks, 3 weeks. They'll say, I'll let you guys amend the pleading and let's get this squared away. Let's get this on going. And that's what they'll do. So they'll amend the pleading at the very least. Yes, Elaine.
Hi. Yeah, don't they make you sign an agreement when you get a credit card? And doesn't that have your name and your address and
Many times. And I'll tell you an example. So I had a case a while back, maybe a couple of years ago, where it was a promissory note and there was a signature on there. It was the defendant's signature. I mean, it matched his name. The name in the defendant was in cursive, his name. Now, someone copied the contract and put it in the pleading as Exhibit A. My argument was exactly what I just told you. Even with his signature on there, I still made that same exact argument. Because why? Why would I do that?
they didn't define you in the contract?
No. Only the defendant can authenticate his own signature. An allegation in a complaint cannot do that. All it can do is create a rebuttable presumption. So I deny that that's my signature. I think it's forgery.
Which is easy.
I'm a layman, Judge. I'm looking at my driver's license and it looks a lot like mine, but I promise you that's not my signature. I think it was a forgery. And everything goes downhill from there for them because they need your testimony they need you to acquiesce by not challenging that. If you don't challenge it, it's as if it is your signature. They can act on that presumption.
Oh, okay.
Yeah. Karen, what'd you think?
Very interesting.
Oh, this is a very interesting topic. What if they go back and they amend their pleading and they bring in several bills that and then it alludes to that, well, you've paid your bill. Like you've paid this on this credit card account, because they bring up that argument.
Good point. Let me go back to this real quick. And so let's go look at Exhibit B for that matter. So we come down to Exhibit B. Now I'm gonna tell you what this Exhibit B is alleging. It's not even evidentiary yet, but it's alleging one thing and very
You're intermittently freezing, John.
Hmm. He lost connection.
oh. Can y'all hear me?
Yes,
Yes.
We
you
lost
lost
you for a
it.
little
Yes.
while.
I've been losing connection lately. Ray, can you hear me? Oh, no.
Yes, I can
Just
hear you.
Ray. Okay. Let's see. So yeah, my internet connection sometimes does this. Lately it's been doing this. So
We lost your screenshot.
okay. Can you see me okay?
Yes.
All right. So Teresa, what did you want to comment?
Hi, everybody. This is so great and it's all new to me. Hi, so on this subject, like my situation where they didn't do what you guys are talking about, they basically, like Bank of America, basically just gave me a 1099, right?
1090 for something for what? For interest on your account?
No, because I didn't pay them. I didn't
Oh,
pay.
okay. Oh, let me explain that one too. I can explain that.
Yeah, please do,
Please.
because now that 1099 is on, what the IRS is coming back to
It's
me.
okay. You can exclude it on your 1040, but if the IRS and so many tens of thousands of these, I've excluded them. And if the creditor sends you a 1099, that is not proper. It just does that. Even a debt collector, as long as you didn't make a new payment plan with them and you're solvent. So here's how it works. In the 90s, there was a letter ruling that letter rulings aren't applicable to everybody. They're just for one transaction, but it caused the IRS to adopt a policy. From what I understand, I don't know where it's written anywhere, but it works every time. The policy is this. A 1099 is for imputed income tax. That means you borrowed money and didn't pay it back. So therefore it becomes taxable income, imputed, right?
Mhm.
The 1099 is for. So the only way that would be you'd be legally liable for that is if you are solvent during that tax period. So most of us are not, including myself. We can show on paper that we're not solvent. Well, if you
Okay, what does solvent mean again?
solvent means you have more debts and obligations than you do income and assets. And
That's me.
yeah, and even my rich clients do this too. They look insolvent. I mean, it's pretty easy to establish insolvency on paper and tell the truth. So most people are by default insolvent just because they have a mortgage, or something like that. So if you're insolvent during that tax period for the 1099, and or there was not a settlement agreement on which you defaulted. If you did not default on a settlement agreement and or
Did he freeze
they're
again?
separately or together, then you're not liable for the 1099.
Okay, good. Good. Okay, go ahead with this amazing conversation.
Just exclude it from your 1040 and you should be fine. If you get a letter for underreporting, let me know.
Oh, no, I've gotten plenty of letters and I'm on your radar, so we'll be
All
talking.
right. All right.
Hey, John, can you go
Yeah.
back to Karen's question and explain what you say to the credit card company when they come back and say, well, you've been paying these bills? Does
Okay,
that show?
so let me just make that complete. Let's go back here. The complete idea here. So we're going to look at the bill, right? So here's the bill. And I'm not, I know sometimes I'm a smart ass, but here's the thing. All this demonstrates here, this exhibit B, is that the plaintiff has a computer and is able to print out papers with words on them. It does not establish an obligation.
Remember that, Ray?
If I use a computer, okay, and I create an invoice like this,
Mhm,
put your name and address on there because I went to Google and I found your name and address or something. Can I make one that just looks just like this?
mhm,
And then I send it to you in the mail and you don't pay me, and then I sue you. And then I go on the internet and I search on this type of contract, which you can find, by the way, on the internet.
mhm.
Notice how there's no name on there and there's no date on there. And then I throw that into the complaint and I say, she didn't pay me and these are the terms of default and now she owes me. What kind of society is that?
Right.
So your billing statement does not establish an obligation.
And they're saying, like, even if there's like 4 of them, that still doesn't.
400,000 of them. It does not establish an obligation.
Mhm,
It just shows that the plaintiff has the ability to print paper with words on it. And this is how I make the legal argument. It doesn't demonstrate anything beyond the plaintiff's ability to print paper with words on it. That's how you say it. And lawyers, it's like you shut them down because their brain doesn't work that way. And the judge will be laughing. He won't be laughing openly, but he'll be thinking to himself, damn, I'm glad I'm not them, you know?
mhm.
Because how do you argue with that? It doesn't, here is the obligation for whom? When did you serve this on him? When was he made knowledgeable of this? Did he sign for this? Did you send by certified mail?
Mhm.
So you just showed up, surprise, there's a bill. You didn't send it in a way that would prove that he received it. First of all, that's number one. Okay, so look how important notice is. Okay, so the pleading alleges that the plaintiff has performed all conditions preceding to bring this action, or the same have been waived by the defendant.
Mhm,
A condition that's preceding to bringing the action is notice.
mhm.
You don't serve notice and give someone a chance to cure a situation, then you cannot get the court to take jurisdiction. So they just made this allegation here without supporting facts. And so that's another naked allegation I like to say. It's an unsupported allegation. If all conditions preceding, first of all, the pleading fails to identify what conditions were preceding. What
Right.
is supposed to be met. It fails to allege that.
Yeah.
Yeah, and then it fails to allege that the plaintiff did those things. So the allegation itself is just lazy.
Mhm.
That's how you make them eat their lunch, right? Eat your
Okay.
lunch. All right, so Teresa, what do you,
Sure.
did you want to ask something else? Oh, you gotta unmute. Go ahead.
No, I didn't, but now I do. Sorry, I didn't lower the hand. So what this is all sounding to me, John, wherever you are, John JJ, everything seems to be like our judicial system are morons, and this is all semantics.
Yeah, it's a racket. There's a need to collect on debts. It's important that you pay debts. So if you come to me and you have a debt situation, I make sure that you understand that you're going to pay grandma back, you're
Oof.
going to pay your doctor back and stuff like that. But when the 90s, I discovered that the banks were not actually lending money. What they're doing is creating money on your application. They're fabricating money that never existed before and acting as if they risked something. They didn't risk anything. Without risk, you can't have an agreement. There's no consideration without risk. So if one party doesn't take any risk, he doesn't have a claim. But this is our system and you're not going to be able to argue that. So I argue it this way.
Mm.
And lawyers just are oblivious to this because they go to a law school that doesn't teach any of.
That is true. And also they're lazy and it doesn't make sense. And they would be ostracized by their colleagues and they would probably not, they would face difficulty in advancing their career. Many lawyers want to be judges. So you kind of have to go along with the status quo, which is wrong. It's a racketeering operation.
Mm.
So I'm just showing you, there's the technical aspects of fighting them and you can actually win. So what I'm showing you right here is very correct. However, the court is not going to let you do it. They're just not going to let you win. And you're going to have to be prepared to appeal it, which if you appeal it, you can make the correct argument and you can get it reversed on appeal. Maybe you have to go back to the trial court and make some more arguments or something, or maybe the appeals court is going to say, no, we're going to reverse the order, the judgment, and the plaintiff takes nothing. But you have to appeal it. And so you're looking at a year and a half or 2 years of your life filing documents, and maybe it's worth it. I don't know. But this is why I came up with the solution, which is like what Alex is saying. You can sue them and they will withdraw the case. In most cases, they will withdraw the case and they will send you a check. Oh yeah. We've gotten the law Zwicker and Associates. We've got them to pay our clients $30,000 and $40,000. $30,000, $5,000, $4,000 because
What would they be paying that for?
because we sue them under the Fair Debt Collection Practices Act for unfair and deceptive collection practices, and also the Telephone Collections Practices Act, which is the big money. Those are worth like $6,000 for every phone call.
Can you
Wow.
say that slowly, what that act is? Say it a little
Yeah,
slower.
this is under Title
You've frozen again.
Poof.
15 of the United States Code, Section 1601 and 1692. Okay, Title 15 USC 1601, 1681, 1692. All these statutes impose penalties on the collection process, and you cannot penalize Discover Bank, for example, the creditor, but you can sue the law firm and the attorney. So each time you do that, you can sue under federal and state law in federal court. So let's say, for example, you sue the law firm. Maybe I think Alex did this. You got the law firm and you got the attorney. So each is worth $1,000. So that's $2,000. But you sue them for 4 counts under your state law provisions of the Fair Debt Collection Practices Act and your federal law provisions of the Fair Debt Collection Practices Act. That's $4,000 right there. Okay. Then you go and look at your credit and see if they're on your credit. You can't sue Discover, but you can sue anybody else. So, it adds up quite fast.
It's a lot of work. I should
Yeah.
add to that.
I even tried to discourage Alex, so he took it on. So.
You did try and discourage me, but I have to say in full transparency that I am doing it to learn. And in addition, we did talk about how to become uncollectible through your strategies first. So that's why it's more of a learning process, and
Yeah,
it's a
we'll
low
get to
risk
that.
for me.
We're going to get to that shortly. So you're asking, what the heck would we sue him for? Well, you think, well, why would I sue the law firm? I know I didn't pay the bill. What cause of action do I have against them? Well, I'm just going to tell you how the statute works. Just because you got a letter from a law firm representing somebody, you have a cause of action. It's that simple. All you do is allege that you are the victim of an unfair and deceptive collection practice. And then now I'm going to give you a scenario as to how you would support that with facts. Okay. So the law firm or the attorney for the law firm, the attorney, like in this Discover case, sues for Discover, right? There's a very good chance that Discover does not have an interest in the case. There's a very good chance that the accounting and the assignment and the claim and the receivable of the Discover credit account is owned by Zwicker and Associates. But they're not going to tell you that because they don't want to be a party to a case. They don't want to be a debt collector. So what they do is they represent Discover, but they're lying.
Wow.
I know this because when I brought this up years ago, the judge, nobody would let me bring it up. So I thought, okay, I'm going to have to go sue him in federal court. When I did that, it was a different world. They started writing my client letters saying, how much will it take to make this go away? And they try to get away with half. And I told my client, I said, no, tell them you're going to take it to the Supreme Court, like act like a maniac. And so they will send you, instead of 50%, we'll send you 100% if you'll sign this contract here, So we did that for several years. It was quite fun, but it is a bit of work. And so we had many video series and we coached people and we looked at their pleadings, and but people had to do it themselves, and it somewhat was arduous, but they did really well. But yeah, that's just one example. I mean, there's all kinds of things you can do. Like the Fair Credit Reporting Act. Okay, that's worth $1,000 per violation. The debt collector's on your credit. Why? Did you borrow money from him? Did he provide you financial services? Did he lend you money? No. So what's he doing? False report. You see? because they don't even have the assignment agreement. I've seen assignment agreements that they never identify the credit account. What they do is they identify batches of accounts that they're all cryptic. Like there's no assignment. It's all fake.
Mhm.
Yeah. Now I'm just talking about the creditor. All right. So then we get into a situation where, all right, here's what I look at. I tell the client, we can argue with them and we can have some fun and file motions. It depends on the client. I mean, some people are so terrified. And so I look at their situation. I say, okay, here's how this works. You got served today or yesterday, and you got 20 days to file a written response. In fact, you have probably 2 months to file a written response, but let's not be late. We could be late, but I've had cases where we're late, they get a default judgment, and then I file a motion to set aside default because I did my best to try to respond timely, and I'm not an attorney and I can't afford one, but here's my answer. And the judge will agree and he'll set aside the default judgment and let the case proceed. You just have to ask. So just know that it's a system, it's a service that we pay for and we can use it. Don't be afraid of it. So here's how I look at it. I look at it in terms of risk. So there's someone making a claim. They're going to use the court to get a judgment so that they can then use the police power of the state to take your stuff. The police power means you apply to the court for a writ of garnishment on your bank account, a wage garnishment on your wages. You can record when they get a judgment lien, they record a certified copy in the county, and that constitutes a lien on any interest you have in real estate. So what you want to do is identify here's how you do it. You make a list of everything that you have the right to spend, money that you have the right to spend, and things you have the right to sell that are exclusive of everyone else. Or if you have a joint and several relationship with the other person, like 2 people on the title of your house, that's still subject to levy. I shouldn't say levy, it's lien. So the way you get out of that is you retitle the property. And you've got to do it fast. You really shouldn't, you have to do it before they record the judgment lien, but you should do it as early as you possibly can, and preferably before you're sued. Okay, so if you want to avoid a lien on your house, you would simply deed the property to a limited liability company. And you can retain the same ownership in the LLC that you had on the title without the LLC, and you're just retitling it. But you do risk the other, the creditor coming in there and trying to attach to the company because the beneficial interests are the same. And I've never seen that. I imagine it could be done, but I've never seen that. So using an LLC to hold title outside of your estate is one way to do it. You can use a trust, of course. The other way is, okay, so for like cash flow and bank accounts, let's say you have a 1099 type income. That's very easy. All you have to do is just, instead of getting the 1099 yourself, whoever's paying you the 1099, you set up a limited liability company. You give notice to the other party, or you just tell them, and you give them a W-9 for the LLC and its EIN. The W-9 certifies the correctness of the EIN, and then that will be immune from collections unless that LLC has a debt, in which case you can reroute it again. So that works really well for independent contractor income, all types of 1099 income, the sale of stock, it works for dividends, all these things. Holding title of real estate, LLCs are perfect for that. Now wages, okay, that's a different creature. Before I talk about that briefly, does anybody want to ask me a question before? Because I have a tendency to talk so fast.
What about Social Security?
That is exempt. That is exempt from debt collectors. And right now, the
Froze again.
exemption is suspended because of that. But pension funds, Social Security, 401ks, IRAs that are not inherited, those are exempt from these collections. So I don't care about those. I only care about things that are not exempt. Now, what's interesting is you lose a lot of your protections if you go into bankruptcy court asking for protection. You will actually lose your protections because what will happen is the court will get you into a payment plan. All right, unless you're insolvent. And if you're insolvent, or if you're qualified for a Chapter 7, then there's really no need to file a bankruptcy. We can get into that too. So Karen, did you want to?
Yeah, just really quick. I researched Colorado debt collection laws, and I think I found that they can't go after the first $2,500 in a bank account. Is that generally true, or?
Yeah, you can apply for exemptions. I like to avoid doing that. I just like to not have the money in the bank account. But
Right.
it comes down. But if I have to, if I get the case at the last, 11th hour. Okay, I'll try to get as much money back from my client as I can. And then going forward, I'll make it to where he can make millions of dollars and their judgment lien won't ever attach. And then one day it'll expire and they'll have never taken anything and my client can get rich. It's not going to affect him at all because I set up everything out of his estate. Now, let me mention on the wages. So here's what I came up with on the wages. Now, wow, this is like back in 2002, 2004, excuse me. So I can argue this stuff like I explained, and it's not worth it to go and appeal and try to win, because you got like a lot of my clients have eight or nine credit card accounts, 6, 8 or 9, whatever. What you got? I mean, he's going to lose his sanity if I do this. It's going to burn up my time. It's going to be too expensive. So instead, we do all this. We restructure the bank accounts. We use limited liability companies, maybe trust organizations. We make it to where there's nothing that's attachable, subject to levy or lien. And then the last remaining things, the wages can be taken from the employer directly before you get them, even because you're entitled to receive them. So they're subject to levy. That's how it works. So here's how you get the levy, the wage garnishment. You apply to the court for a writ of garnishment against wages, continuing a writ of garnishment against wages, and the court will grant the writ. And then the plaintiff goes to the clerk of the court and says, whatever, serve this on the employer or whatever. So then the employer withholds. Now, if he doesn't, I believe the penalty is 2 times what was going to be garnished. He has to pay. So the employer is going to withhold your money. Now, the limitation is under the Consumer Credit Protection Act. And typically it's 25% of your take-home pay. In New York, it's 10%. California is 25%. Some states are less than 25%, but no more than 25%. Now, here's the interesting thing that I discovered. Once a creditor gets a wage garnishment for the whole 25%, you might get notices saying, hey, if you want to reduce the amount we're levying, fill out these forms, claim exemptions, which you can do, right? So if you claim exemptions, what happens is, let's say you're exempt enough to where the 25% now is reduced to 15%. Here's what happens. You waive all your protections under the Consumer Credit Protection Act. Before you do this, your employer cannot fire you without being subject to civil and criminal penalties. If you get an exemption and reduce the amount of wage garnishment to like 15% or 10% or something, then you've waived all these penalties and your employer can then fire you without consequence. Not that he will, but this is how it works. You also open the door to another creditor getting a wage garnishment and filling in that difference again. So now you'll have 2 creditors, one for 15% and one for 10%, for example. So does it make sense to just let one creditor garnish your wages for 25%? That makes total sense. Because if you don't know anything else, that's a headache, by the way, because people say, can I negotiate with my creditor? Yeah, you already did that. And you owe. You can't change that now. You can't negotiate with them now. They have a claim against you and they're gonna get their pound of flesh. So people, they're misinformed. You can't negotiate with them because here's what happens. Let's say your attorney gets you a 50% deal. So let's say Discover Bank says, okay, instead of paying us $10,000, you can pay us $5,000 and we'll leave you alone. It's a trick. Here's what they do. They take your $5,000 and they send you a 1099 for another $5,000 and they get their other $5,000 from the United States government from all the people that filed 1040s. So we're all paying each other's debt like this. It's disgusting. They're just such liars, right? So that's why I say never settle, never pay, never be nice, unless it's your grandma, and don't borrow money from your grandma. Alex?
So I didn't know that about the 1099. It's just more infuriating. But I just wanted to really quick make a public service announcement here and tell everybody that they should sign up for the videos and stuff on your courses because
I appreciate
I've
that.
learned so much like over the past bunch of years that we've been talking and you've been helping me with this stuff and it's totally worth it. and I love learning about this stuff. So I'm a little bit of a weirdo about that because you did try and discourage me. So I'll give you that.
Yeah.
But it is a lot of work, but it's totally worth it because you really understand. I understand the system so much better now, and I'm not afraid of the law anymore
Yeah,
because of all this.
if the law is available to us, we
Yeah.
have every right to use it. It's being blocked.
Yeah.
So we definitely want to do that. So
So that's it.
no, thank you, Alex. So that's what you look at, right? So let's say you just don't even understand all this stuff and you just make your property uncollectible, your bank accounts and all that. And the only thing you don't protect is your wages. And you're going to suffer a 25% garnishment, and you're not going to get a 1099, or if you do, it's going to be erroneous. You're not going to have the tax consequences. You're going to, now I'm going to give you, if you were to do this, let's say you have 8 creditors, and let's say they're all going to sue you. And the first one sues you because it's very diligent. Let's say Amex. Amex is very diligent, by the way. So Amex sues you and gets a judgment lien and garnishes your wages for 25%. Then Discover sues you. Then Citibank sues you. And they get judgment liens against you for $5,000, $50,000. And the second judgment lien after American Express applies for a writ of garnishment. And the clerk of the court says, sorry, there's already one pending. You have to wait in line. This is what happens. So if the first creditor to garnish your wages is there for, let's say, 5 years, there's a very good chance that the other creditors were going to just let it expire. They'll never be watching the record to see when Amex is done with you. Now in New Jersey, it's a little different because New Jersey makes them rotate every 90 days or so. So it's a little bit more difficult in New Jersey. But you can, yeah, you can do it like this. Now, so here's what I can. Before I tell you this, I want to see if Colonel wants to say something. I'll show you guys what I did to overcome this. What do you have, Colonel?
Hey there, John. I have a quick inheritance question.
Okay.
So I know the IRS can potentially seize inherited funds if they come to you directly and you have an outstanding, federal tax debt. And I know the solution to creating immunity from a seizure is to have the inheritance left in the name of a trust or an LLC. But if that's not the case, and if the inheritance is left in your personal name, what is the likelihood of the IRS seizing the funds before quickly transferring the funds into,
Well, okay, so you're just saying, so if you're lucky, you can do that. If you are able to do that before there's an actual notice of levy, then you'll get around them. You just have to be lucky, fast, fast or lucky.
Oh my goodness. Okay, so it's about luck.
I'll give you an example of just one that wasn't based on luck, but this woman, she had like a $40,000 real estate sales commission, and she had all these levies on her bank accounts, and they took everything pretty much. And she needed to clear these funds, and the commission check is made in her name. So she's like right there, like standing on the railroad tracks. Okay. So I had her set up with her sister, or not her daughter. She and her daughter, I had them set up a limited liability company. And then I registered a fictitious name for the company, with her name being the fictitious name. So that way the check could be cleared in the company by the bank. The bank wouldn't care because the fictitious name was her name. So at the bank where they were freezing all her accounts and levying everything, we opened a new account this way, cleared the funds right next to all the accounts that were being levied. They didn't touch a thing. So the liability comes to, if you have the right to spend or sell, they can take it. So just make it to where you don't have the right to spend or sell. If it's not all your money, then like she and her daughter, then it wasn't hers and it wasn't her daughter's. So it was nobody's. It was both of them together, but both of them together did not have the same claim, same liability. So that's how it worked.
Okay, I understand. So how quickly does this have to be kind of executed? I'm assuming immediately. And I'm also assuming that there's a pretty significant chance that they can seize the funds even before you get a chance to move them over.
Possibly. So take the money quickly and put it out of your name into an LLC or something, or put it in gold real quick, as soon as you can.
Okay,
That's all I can tell you.
okay.
All right. So here's what I did. So we had high volume of clients, okay, lots of credit card debt in the 2002, 2004 period. And I hired a programmer to write special coding. So when we took in a new client, we had a database of our clients that was separate from all the other clients, as you would, but then with their permission, we grouped them into threes based on where they lived. Groups of three. These are strangers. They don't know each other, but they understand the program. They wanted to do it. So we had them sue each other. Now, once they sued each other on a base, it was so simple. That allowed each of them to acquire a wage garnishment against each other. And then they wrote assignments to each other so that they can always be relinquished from that without ever having to call that person again. Like they never became friends because they were, they have all their documents. And then after that, they were done with it. They didn't need to call these people again. There was just this stranger with a lien on them. It was a wage garnishment that was sitting there at the clerk of the court and not served on the employer, and it was blocking everybody else. That's what happens because of the Consumer Credit Protection Act. So instead of letting that first creditor garnish the 25%, my client became that first creditor. Why pay me if you don't have to? And it was a bit of work, but it actually functioned very well. Basically, all we did was drop the paperwork. We made it so smooth. All they did was sign stuff, file it, and it worked perfectly, really. So anyways, I'm not saying you have to do that, but it is something that you could do. And like I said, you can beat them totally without fighting them in court. Here's where you really win, though. Here's where you really get ahead. If you understand a better use of your money, don't pay the creditor for an old debt. Pay going forward. Like, I'll pay a debt for marketing so I can draw more sales. I'm not going to go pay my credit card bill that I'm never going to use again. It's a better use of capital. That's plain and simple. I'm not trying to be a nice guy there. I'm just trying to use my money better because, people depend on me, right? So I'm not trying to be nice to the bank. I'm going to be nice to my children. Care about them first. All right. Yeah, that was very crazy. And everybody said, John, that'll never work. And I said, yeah, you're probably right. Let's try it anyways. And they all did it. And it did work 100%. That's craziness. I don't do that anymore. I don't know why, but it was a bit complicated. I mean, I don't know that I want to go do that drama again, but oh my gosh. But anyways, so the limited liability company, here's where it's so important. It allows the ownership to be different than your individual ownership of something. So if myself and my brother are owners of an LLC and that LLC is taking over my property rights, and maybe it's my brother's property rights too. He and I are going to work together. We're not going to have problems. As long as he and I don't sign a commercial lease together, or we don't file joint tax returns or have a joint liability, my older debts will never attach to the money into the LLC. Same for his. He could even file bankruptcy. It's isolating that property from the rest of the world, from everything going forward and from everything in behind it. This is really such a clean way. So what you're doing is you're divesting your exclusive rights to property, and you're divesting it into a group that doesn't have the same liability that you did individually. But you're still retaining control. And this is the cornerstone of asset protection and estate planning that lawyers won't tell you. They want you to think they're like some Harry Potter, black box. Ooh, you need to pay me $10,000 so I can save your ass. You don't. Just understand that you're dealing with property rights. And the reason why you care about lawsuits and things is because your property rights are not set up in a way that would defeat them, because you don't know that. The risk is the property rights. You change your property rights, you change your risk. Good thing, Teresa.
Oh, okay. So why do I hear that the irrevocable express trust is the one that you can't pierce, and as opposed to an LLC?
Yeah, thanks for bringing that up. So I like trusts that are irrevocable, but the only problem with the trust is that it's not a matter of statute like an LLC is. So the articles that are recorded with the Secretary of State on their face is enough to defeat a creditor. Whereas a trust, it might be the most brilliantly written trust, but what's going to happen is during post-judgment discovery, the attorney may subpoena the trust document to break, are written by attorneys, and that's what they do. They make it to where things can be broken. They make it that way.
Right.
So if you want to use a trust, you need to know how to defend it, and you have to defend it. No lawyer is going to do it. So that's the problem with the trust is, like, for example, let's say you had some property over here in a trust and you have a debt collection, and then the bank wins or whatever, and then they're trying to do post-judgment discovery and seizing assets, and they're going to argue to the court, they're going to say, this woman has a trust over here she's using, it's associated with her in some way. Or they get you into post-judgment discovery in a deposition, and they ask you if you're associated with a trust, and you have to tell them. And so the attorney is going to subpoena your trust documents, and you're going to have to give it or go to jail. They'll get them, and invariably in most cases they're probably right. Most of the time, trust organizations are not written, and they're not executed properly. People don't understand there needs to be an arm's length separation, right? So a lot of times what I find is the person who's using a trust thinks he owns the trust and is the trustee and is also the beneficiary or some combination of that, right? So there's no trust. So I don't like to analyze it if I don't have to, but I'll usually just change the trustee to a limited liability company, you know? So I want something that on its face prevents the need to defend it, because that then is the risk and the cost of litigation. You're going to incur that. So if you have an attorney defending it, now it's costly to defend something. You better hope you have it written correctly. And you can write a trust that's pretty strong. I wouldn't rely on these people that are selling them like this as the end all. I'll give you an
So
example.
LLC is the bee's knees. It's
The
the way.
LLC, because I don't need to be a smart guy to write the contract. All I need to do is list the two names of a non-married two people in the articles. That's all I got to do. The statute does the rest. Now, if I'm in another country and they're, let's say Canada or Australia,
Shoot.
Frozen again.
technology. All right, you guys got me? You hear me?
Yes, thank you.
So the statute gives you the protection, right? So no one's going to argue with that. It's a matter of law. So here's the cool thing. If a creditor, a lawyer for his client, is so bold as to ask the court for what's called a writ of attachment on the property in the LLC that you're an owner of, you and your brother, for example, are the owner, and you're the debtor to something else, and the brilliant attorney gets a charging order, what's called it's called a charging order, a writ of attachment, okay, against your interest in the company, he can get it. But if he's not able to levy the property, and he can only levy the property, he can only take the money from the company when the company sends you money. He can't reach into the company and take it before you decide to pay yourself. And because you're the boss, what happens? I'm going to tell you what happens. If he doesn't collect the money, or he collects only part of it, whatever amount on the writ of attachment, the judge says, yeah, you can go get your $27,000. If he doesn't collect that, his client will owe taxes on the amount he did not collect. No lawyer is going to risk that, because he's done then. Nobody's going to hire him anymore. He's just stupid. So
We're talking about the IRS being the debtor.
well, so the IRS is kind of like, if you guys are, I'm a Star Trek fan, so the IRS is a little bit different than your lawyers that are doing debt collections. The IRS is kind of like the Borg. If you go aboard the Borg ship and you don't poke them in the eye or threaten them or something, they'll leave you alone. They're menacing, but they'll leave you alone. That's how the IRS is. So yeah, so don't poke your head up is what, so don't incur the tax liability or don't have the exclusive rights to something or don't incur that report that shows you received dollars for the disposition of property, like selling cryptos. If you can avoid that, you're going to avoid the IRS. Yeah. Yeah, I don't know what's up with my Wi-Fi. I've been having a problem for like 2 weeks now. So anyways, I hope that gives you an idea. And this is what I talk about all the time, changing your property rights. And we use the tool of the limited liability company. But the core of it is that you're divesting your exclusive rights to spend or sell. You're divesting it into a group. You're transferring it into a group, but you're retaining control. And on the record, it looks like you don't have those rights. And even though they might think you do, it doesn't matter. They can see it, but they can't touch it.
An LLC is the best way to go.
It is in the States, yes. And you can do it with a partnership, but like I said, you need to know what you're doing. You need to understand what happens in post-judgment discovery. It's like the example of people setting up nominee companies in Panama, right? And they just move their dollars over there, thinking that somehow, they're not taxable or whatever, and they're immune from collections. And then what happens is somebody sues them and they get them in the district court. And they bring up this issue of their relationship to the company. And the guy says, hey, well, I'm not an owner and I'm not a signer. And the judge looks at all the income statements and he says, well, it looks like all the money is going to some benefit that you have. So I'm going to order you to repatriate the funds or I'm going to put you in jail for contempt. So all that brilliant planning and the money you spend on that fancy name structure, your Panama, this and that, is defeated by the rules of civil procedure and post-judgment discovery. It's so simple, but nobody talks about that. But the LLC will overcome that. The LLC, everybody can see it. And your first concern is getting out of having to incur the cost of litigation for defending something. If you've done that, you're going to win. You've already won. If you don't have to defend it, you've already won. All right, so hopefully this is one continuous recording.
Excellent. It was excellent.
Yeah, I will publish it. But I hope this helps you all understand and just, it's unfortunate if you're in that situation, but always think, what's the best use of my money? Don't think about how this is going to look on my credit. What are my friends going to think if I get sued? Who cares? Best use of capital. Even paying your mortgage in advance. Don't do that, Yeah.
I mean, paying in advance. I mean, if it's due on the 1st, I pay it on.
Pay your mortgage on time, but I'm just saying, don't pay off your mortgage in one lump sum. That's a bad use of capital. Yeah, I mean, think about it. You're putting in your cash into a liability. So a lot of people want to make return on their money, and they're like, "Yeah, I made a return. I made 8%. I made this and that," and then they pay off the mortgage, and they get what they're doing is they're making like negative 47% on their money. Just making up a number, but I'm just saying it's dramatic. You struggle to make 8%, and then you just dump a bunch of cash into an old liability that you didn't have to do, and now you got more taxes to pay probably, and your return on capital is like negative 40%.
So what do you think about somebody just buying a house outright in cash? And
it's easier to do that if you can, but you should have a plan to get some financing with a decent chunk of it, like half of it within a few months. Just like buying gold. I'm going to buy gold because in 3 to 6 months, I'm going to reallocate that into something else that's going to make me some money. That would be my only reason. So if I want to pay cash for some liability, okay, then, but I'm going to do it for convenience, but then I'm going to finance my way out of it. What if I put cash into an asset? People would say, well, I'm making money with it. Okay, but then you're your own lender, like I've explained before. You're not a lender. Don't act like one, because it's not a risk you're suited to take. A lender is suited to take that risk. And just so you know, banks aren't lenders, they're borrowers.
So can you define what a lender is then? Who is
a lender? Is someone who takes his own money and lets someone else use it for money. He charges you a fee for using his money. That's a lender. Banks don't do that. Banks, well, they create money, but what happens is, if you borrow money for a mortgage, for example, I use that term loosely, the bank is only going to do that because it can call another bank and have the bank buy the paper. So really what the bank is doing is acting like a broker dealer. if you look at the statutes, that's exactly what the banks are doing. In fact, that's what your car dealers are doing too. Car dealerships are not selling cars. They're selling paper like a bank. They are broker dealers just like your mortgage lender.
Mhm.
But they're not lending. They are always borrowing.
You know, they sell the note.
It just goes up the chain. Yeah. So at some point, there's a lending institution that is gonna park that paper and it's gonna sell an interest in that paper in some kind of security. So there again, they're always passing the risk off, and the risk always comes back onto us. It comes back in our 401ks, our IRAs. So all of our consumer debt comes right back to us. It's a very clever system.
Got a question.
Yeah. Okay.
On the, if somebody creates a LLC in their name, you know, for inheritance, like you were mentioning earlier, does it require a special operating agreement?
No, because in fact, it doesn't even, no LLCs require an operating agreement because no one's going to discover it. However, if someone wants to challenge the operating agreement, you should have something that would be substantive to what you're trying to accomplish. All right. It should be suitable for what you're trying to use it for. So there should be an operating agreement, but no one's going to ask you for it unless there's like someone's trying to make a claim on the company for some reason. I've never seen someone ask for an operating agreement, by the way.
Okay, just have it in your name and multi-member and
It's
and then
enough
have an
to,
operating agreement. But
yeah, it's enough to title income in the name of an LLC without regard to the ownership. If you want a really strong position, you want to have ownership that's not just you by yourself. And it should be you and not your spouse. It should be like you and another friend or, you know, a sibling or a child, an adult child.
Right. Okay.
All right. Well, good. I appreciate you guys participating. I hope this gives you some insight.
This is
Useful.
amazing.
It was a
Thank you
great,
very much.
great class. Thank
Yeah,
you.
excellent, John,
Okay.
as always.
Great call.
All right.
You.
Enjoy your weekend, y'all.
You
Thank
too.
you.
You too.
Bye-bye.